What's going on? Most of it's under seal, so I'm still working on that in the private as far as getting the petition and all that together. I got some more provisions to be requesting from chat, so I'll be covering it in the future on the workshop, but right now I'm still working on it. What's going on, Roots? So, let me see what I'm looking at. What was it? Let me see. Should I write the king as his title? King's prerogative. Alright, so what we're reading out of this time is going to be Blackstone's Commentaries on the Laws of England. Now, this is, I've heard it referred to a couple different ways. One is black letter law or something like that. Another one is, I believe it was mentioned by Christian Walters as well. So this is pretty in-depth as far as England and its law system. Specifically, what I'm looking to cover is execution or writs of execution. So writs of execution, basically, basically like something that once you've already had a judgment in court, let's say, whatever corporation, was doing something wrong and you were able to sue them
and get them declared judgment debtor. Then the court declared that they had to pay XYZ amount. Well, that's only the first half of the process. The other half is getting, well, in some cases it would be termed garnishment, but most of the time it's a writ of execution or collection on the judgment. And that collection is essentially what compels them to pay the already acquired judgment. So this is something that, especially with, dealing with these types of processes, ancient writs and other things, it stems back from England. And since England was here in America, it still applies even today. So let me see. So it says here, of execution. There now remains nothing to speak of but execution, the completion of human punishment. And this, in all cases, as well as capital as otherwise, must be performed by the legal officer, the sheriff or his deputy, whose warrant for so doing was anciently by precept under the hand and seal of the judge, as it is still practiced in the court of the Lord High Steward, upon the execution of a peer, though in the court of the peers in Parliament it is done by writ from the king. Afterwards it was established that in the case of life the judge may command execution to be done without any writ. And now the usage is for the judge to sign the calendar or list of all the prisoners' names with their separate judgments in the margin, which is left with the sheriff. As for a capital felony, it is written opposite to the prisoner's name, hanged by the neck. Formerly, in the days of Latin and abbreviation, sif per col, I'm not sure what that is, suspendatur per colum. And this is the only warrant that the sheriff has for so material an act as taking away the life of another. It may certainly afford matter of speculation that in civil causes there should be such a variety of writs of execution to recover a trifling debt, issued in the king's name and under the seal of the court, without which the sheriff cannot legally stir one step, and yet that the execution of a man, the most important and terrible task of any, should depend upon a marginal note. The sheriff, upon receipt of his warrant, is to do execution within a convenient time, which in the country is also left at large. In London, indeed, a more solemn and becoming exactness is used, both in the warrant of execution and the time of executing thereof. For the recorder, after reporting to the king in person the case of the several prisoners and receiving his royal pleasure that the law must take its course, issues his warrant to the sheriffs, directing them to do execution on the day and the place assigned. And in the court of King's Bench, if the prisoner be tried at the bar, or be brought there by habeas corpus, which is another writ, a rule is made for his execution, either specifying the time and place, or leaving it to the discretion of the sheriff. And throughout the kingdom, by statute, it is enacted that in the case of murder, the judge shall in his sentence direct execution to be performed on the next day, but one after sentence passed. It has been well observed that it is of great importance that the punishment should follow the crime as early as possible, that the prospect of gratification of advantage which tempts a man to commit the crime should instantly awake the attendant idea of punishment. Delay of execution serves only to separate these ideas, and then the execution itself affects the minds of the spectators rather as a terrible fight than as the necessary consequences of transgression. The sheriff cannot alter the manner of execution by substituting one death for another, without being guilty of felony himself, as has been formerly said. It is held also by Sir Edward Coke and Sir Matthew Hale that even the king cannot change the punishment of the law, by altering the hanging or burning into beheading, though when beheading is part of the sentence, the king may remit the rest. And notwithstanding some examples to the contrary, Sir Edward Coke stoutly maintains that, quote, judicandum est legibus non exemplis. But others have thought, and more justly, that this prerogative, being founded in mercy and immemorially exercised by the crown, is part of the common law. I'm going to look up this is. Not familiar with this one. Of course. We must judge by the laws, not by examples. That's what it means. Sir Edward Coke. Okay. Judge by the laws, not examples. Okay. But others have thought, and more justly, that this prerogative being founded in a common law. Okay. For hitherto, in every instance, all these exchanges have been more merciful kinds of death, and how far this may also fall within the king's power of granting conditional pardons, viz., by remitting a severe kind of death on condition the criminal submits to a milder, is a matter that may bear consideration. It is observable that when Lord Stafford was executed for the popish plot in the reign of King Charles II, the then sheriffs of London, having received the king's writ for beheading him, petitioned the House of Lords for a command or order from their lordships how the said judgment should be executed. For he being prosecuted by impeachment, they entertained a notion, which is said to have been countenanced by Lord Russell, that the king could not pardon any part of the sentence. The Lords resolved that the scruples of the sheriffs were unnecessary, and declared that the king's writ ought to be obeyed. Disappointed of raising a flame in the assembly, they immediately signified to the House of Commons by one of the members that they were not satisfied as the power of the said writ. That House took 2 days to consider of it, and then sullenly resolved that the House was content that the sheriff do execute Lord Stafford by severing his head from his body. It is farther related that when afterwards the same Lord Russell was condemned for high treason upon the indictment, the king, while he remitted the ignominious part of the sentence, observed that his lordship would now find he was possessed of that prerogative, which is in the case of Lord Stafford had been denied, or he had denied him. One can hardly determine at this instance, from those turbulent times, which most to disapprove of, the indecent and sanguinary zeal of the subject, or the cool and cruel sarcasm of the sovereign. To conclude, it is clear that if upon judgment to be hanged by the neck till he is dead, the criminal be not thoroughly killed, but revives, the sheriff must hang him again, for the former hanging has no execution of the sentence. And if a false tenderness were to be indulged in such cases, a multitude of collusions might ensue. Nay, even while abjurations were in force, such a criminal, so reviving, was not allowed to take sanctuary and abjure the realm, but his fleeing to sanctuary was held an escape in the officer. And having thus arrived at the last stage of criminal proceedings or execution, the end and completion of human punishment, which was the sixth and last head to be considered under the division of public wrongs. What's going on, John? The fourth and last object of the laws of England, it may now seem high time to put a period to these commentaries, which the author is very sensible, have already swelled too great a length. But he cannot diminish the student, for whose use alone these rudiments are originally compiled, without endeavoring to recall to his memory some principal outlines of the legal constitution of this country, by a short historical review of the most considerable revolutions that have happened in the laws of England, from the earliest to the present times. And this task he will attempt to discharge, however imperfectly, in the next or concluding chapter. So, a writ of execution is one. Now, there's a symbolic execution, which is what we have today, and there's an actual capital punishment. The original capital punishment was the severing of the head, or the hanging by the head, the neck. But in place of this today, for the most part, other than, the death sentence and other most places, writs of execution for sums of money are seen as severing the head of the person, not the living man or woman. So the person is rent asunder, and they have to pay out of their treasuries or their stores. So when people are seen under writs of execution, this is what they're essentially attacking one's person for the rendering of the account and to satisfy the judgment. The writ of execution is the completion of the sentence. Yes, well, the caps is dealing with capital. They're stating that your corporate person is the body corporate, that, if you are separated from, that is the execution, because then they take the funds directly out of your personal holdings and stuff like that. Honestly, I don't know, Connect if that would really do quite that much. Because realistically, I don't think the birth state has a thing unless it's Minnesota. So, but yeah. So, that's something. As far as execution go, that is what's happening. It's happening to one's person. So one's person is actually what's being rent. And it's either separation or the breaking of the neck or the connection between the head and the body. The head being the capital or capitis. Capitis means head. So capitis diminutio means diminishment of the head. This is why, movies like Killers of the Flower Moon, we're talking about head rights. It's talking about rights to just direct the use of the capital. It's the governing power. Do I have control? I mean, yeah. Yeah, I mean, I'm not sure what angle you're, aiming with that. But, I mean, as far as control, I mean, yeah. But, yeah. So, Blackstones, let me see what else. Ooh, that's a long one. Legalize the partition. What partition are you talking about? 14th Amendment, register trademark? Cup rule, where you listed as the owner, not just a holder. Well, the thing is, you can't be the owner of these fictitious names. Or you can be the owner of the names, but the name itself, the fictitious name, is what owns the bank account. There's no way, because these entities, everything is, business. Oh, you're talking about that. I've done name change from all caps to upper and lower. I've set up trusts. I've set up other types of business to regain control of that. So there's a method to it in separating yourself from that name. Realistically, you want to set it up as a business. And you want to separate the liability from the upper and lower names. So, because there's really no way to operate without it. You have to have some means of operation. But it's understanding what makes a name fictitious and what makes a name real. Yeah, I've done the powers of attorney. Yeah, powers of attorney are very important. There's a couple things, 2848, durable power of attorney, etc., things like that. Yeah, it's like I said, it's made, there's certain things you can do, hold harmless and indemnity agreements, commercial security agreements, assume names, trusts, foreign express trusts, revocable and irrevocable. Making sure that you have your assets segregated between operating entities, holding entities, and private reserves. What else? Yeah. You always want to make sure that you're separating from that fictitious name. You don't want to be seen as fictitious, because then they say you don't exist. So the middle name, there's no such thing as a middle name. It never was and never will be. And if you are construed to have a middle name, well, they'll treat you like you're fictitious. So you do have to make sure that is taken care of. And then on top of that, the reversion of the names, putting your first name or first middle before your surname or last name, turns it into a business as well. So those two things alone turn your name into a business, regardless of how it's spelled, or whether it's in the case, style, and any of that. Just the order alone will create a fiction. This is what I want. Yeah, it's really an intestate estate. until you have certain things in place for proving the age of majority. Once you go through court, it's no longer considered intestate. Uh-huh. Alright, so spiritual courts, or ecclesiastical courts. Of course, ecclesiastical, military, and maritime. So, private wrongs. Do you have a Telegram group? I don't have a Telegram group, per se. I have a private Telegram that I use just to stuff like, little stuff, but not necessarily like a Telegram group. I have a private Signal group for the workshops. I have I have Zoom calls like Mondays and Fridays at 7 p.m. Eastern, where we cover all the stuff I can't talk about right now. There's quite a number of things that I'm actually not able to talk about in the public, just due to, honestly, public trust. But yeah, no, I mean, I do have a Telegram, but not necessarily like a Telegram group. So let me see. So it says here, of courts, ecclesiastical, military, and maritime, besides the several courts which were treated in the preceding chapter, and in which all injuries are redressed, that fall under the cognizance of common law of England. Common law of England, or that spirit of equity which ought to be its consistent attendant. There still remain some other courts of jurisdiction equally public and general, which take cognizance of other species of injuries of an ecclesiastical, military, and maritime nature. Therefore, are properly distinguished by the title of the ecclesiastical courts, courts military, and courts maritime. Before I descend to consider particular ecclesiastical courts, I must first of all in general premise that in the time of our Saxon ancestors there was no sort of distinction between the lay and ecclesiastical jurisdiction, meaning there was no separation between court spiritual and temporal. The county court was as much a spiritual as a temporal tribunal. The rights of the church were ascertained and asserted at the same time and by the same judges as the rights of the laity. For this purpose, the bishop of the diocese and the alderman, or in his absence the sheriff of the county, used to fit together in the county court, and had there the cognizance of all causes, as well as ecclesiastical as civil, a superior deference paid to the bishop's opinion in the spiritual matters, and to that of the law of judges in temporal. The union of power was very advantageous to them. Both the presence of the bishop added weight and reverence to the sheriff's proceedings, and the authority of the sheriff was equally useful to the bishop, by enforcing obedience to his decrees in such refractory offenders, as would otherwise have despised the thunder of mere ecclesiastical censors. But so moderate and rational a plan was wholly inconsistent with those views of ambition that were then forming by the court of Rome. It soon became an established maxim in the papal system of policy that all ecclesiastical persons in ecclesiastical causes should be solely and entirely subject to ecclesiastical jurisdiction only, which jurisdiction was supposed to be lodged in the first place and immediately in the Pope by divine indefeasible right and investiture from Shrift himself. Shrift. That's interesting. Shrift himself, and derived from the Pope to all inferior tribunals, Hence, the canon law lays it down as a rule that sacerdotes e regibus honorandi sunt non judicandi. I gotta look that up. Sacerdotes is supposed to be sacred. Regibus, I'm not quite sure. Let's look it up. That's what the decedent's estate was actually created to do. It was created to alienate the soul. It was created for that specific purpose. The clergy are to be honored by kings, but not judged by them. Ah. Okay, so that's what it says. Clergy are to be honored by kings, but not judged by them. Okay. And places an emphatical reliance on a fabulous tale, which it tells the Emperor Constantine, that when some petitions were brought to him imploring the aid of his authority against certain of his bishops accused of oppression and injustice, he caused, says the Holy Canon, the petitions to be burnt in their presence, dismissing them with his valediction, ite et inter vos casos vestras discutite quia dignum non est. Ut non judicamus Deus. I gotta see what this is. Right. You're right, John. You're right. Of giving short shrift, meaning not giving it much thought. Definition, thought of active striving. Absolution given by a high priest. Huh. It stuck out to me because I've seen this same term in an anime. I'm gonna look it up in a sec. But first, I don't read Latin that well. So I'm gonna figure out what this says first. I'm not perfect. Courts Ecclesiastical. Why does this do this? Here we go. Alright, let's find out what this means. Yeah. Everything has its own meaning in different realms. Go and discuss your causes among yourselves, for it is not fit that we should judge gods. Oh! If that's not telling you how the Vatican is, I don't know what is. Wow. It was not, however, till after the Norman conquest that this doctrine was received in England. with the separation of the spiritual and temporal. Ordinance of William the First, 1060s to 1070s. Wow, that's wild. When William the First, whose title was warmly espoused by the monasteries which he liberally endowed, and by the foreign clergy, whom he brought over in shoals from France and Italy, and planted in the best preferments of the English Church, was at length prevailed upon to establish his fatal encroachment. I'm gonna have to look into that. Foreign prevailed upon, and separate the ecclesiastical court from the civil, whether actuated by principles of bigotry or by those of more refined policy, in order to discountenance the laws of King Edward, abounding with the spirit of Saxon liberty, is not altogether certain. But the latter, if not the cause, was undoubted the consequence of the separation, for the Saxon laws were soon overborne by the Norman justiciaries. Oh wow. When the county court fell into disregard by the bishop's withdrawing his presence, in obedience to the charter of the conqueror, which prohibited any spiritual cause from being tried in the secular courts, and commanded the suitors to appear before the bishop only, whose decisions were directed to conform to the canon law. King Henry I, at his accession, among other restorations of the laws of King Edward the Confessor, revived this in the union of the civil and ecclesiastical courts, which was according to Sir Edward Coke. After the great heat of the conquest was past, only a restitution of the ancient law of England. This, however, was ill relished by the popish clergy, who, under the guidance of that arrogant prelate Archbishop Anselm, very early disapproved of a measure that put them on a level with the profane laity, and subjected spiritual men and causes to the inspection of the secular magistrates, and therefore in their synod at Westminster they ordained that no bishop should attend the discussion of temporal causes, which soon dissolved this newly effected union. And when, upon the death of King Henry I, the usurper Stephen was brought in and supported by the clergy, we find one article of the oath which they imposed upon him was that ecclesiastical persons and ecclesiastical causes should be subject only to the bishop's jurisdiction. And as it was about this time that the contest and emulation began between the laws of England and those of Rome, the temporal courts adhering to the former, and the spiritual adopting the latter, as their rule of proceeding, this widened the breach between them, and made a coalition afterwards impracticable, which probably would else have been effected by the general reformation of the Church. In briefly recounting the various species of ecclesiastical courts, or as they are often styled, courts Christian, I shall begin with the lowest, and so ascend gradually to the Supreme Court of Appeal. The Archdeacon's Court is the most inferior court in the whole ecclesiastical policy. It is held in the Archdeacon's absence before a judge appointed by himself and called his official, and its jurisdiction is sometimes in concurrence with, sometimes in exclusion of, the bishop's court of the diocese. From hence, however, by Statute 24 of Henry VIII, there lies an appeal to that of the bishop. The consistory court of every diocesan bishop is held in their several cathedrals for the trial of all ecclesiastical causes arising within their respective dioceses. The bishop's chancellor, or his commissary, is the judge, and from his sentence there lies an appeal, by virtue of the same statute, to the archbishop of each province respectively. The Court of Arches is a court of appeal belonging to the archbishop of each province, whereof the judge is called the Dean of Arches, because he has anciently held his court in the church of Saint Mary Le Beau, Sancta Maria de Arcubus, though all the principal spiritual courts are now held at the Doctors' Commons. His proper jurisdiction is only over the 13 peculiar parishes belonging to the Archbishop in London, but the office of Dean of the Arches having been for a long time united with that of the Archbishop's principal official, he now, in the right of the last mentioned office, receives and determines appeals from the sentences of all inferior ecclesiastical courts within the province. And from him there lies an appeal to the king in chancery, that is, to a court of delegates, appointed under the king's great seal, by statute. As supreme head of the English Church in the place of the Bishop of Rome, who formerly exercised his jurisdiction, which circumstance alone would furnish the reason why the popish clergy were so anxious to separate the spiritual court from the temporal. Oh my, I need to read that again. Yeah. His proper jurisdiction is only the 13 peculiar parishes belonging to the Archbishop in London, but the office of Dean of the Arches, having been for a long time united with that of the Archbishop's principal official, he now, in the right of the last mentioned office, receives and determines appeals from the sentences of all inferior ecclesiastical courts within the province. And from him there lies an appeal to the king in chancery, that is, to a court of delegates appointed under the king's great seal, by statute of 25 of Henry VIII, as supreme head of the English Church, in the place of the Bishop of Rome, who formerly exercised his jurisdiction, which circumstance alone will furnish the reason why the popish clergy were so anxious to separate the spiritual court from the temporal. The Court of Peculiars is a branch of an annex to the Court of Arches. It was a jurisdiction over all those parishes dispersed through the province of Canterbury, in the midst of these other dioceses, of other dioceses, which are exempt from the ordinary's jurisdiction and subject to the metropolitan only. All ecclesiastical causes arising within these peculiar or exempt jurisdictions are originally cognizable by this court, from which an appeal lay formerly to the Pope, but now, by the statute 25 of Henry VIII, to the king in chancery. Okay. The prerogative court is established for the trial of all testamentary causes, where the deceased has left bona notabilia, valuable goods of note, within two different dioceses, in which case the probate of wills belongs, as we have formerly seen, to the Archbishop of the province, by way of special prerogative. And all causes relating to the wills, administrations, or legacies of such persons are originally cognizable herein, before a judge, appointed by the Archbishop, called the judge of the prerogative court, from whom an appeal lies by statute 25 Henry VIII, to the king in chancery instead of the Pope as formerly. Well, these are the Roman courts. I pass by such ecclesiastical courts as I have only what is called a voluntary and not a contentious jurisdiction, which are merely concerned in doing or selling what no one opposes, and which keep an open office for that purpose, as granting dispensations, licenses, faculties, and other remnants of papal extortions, and other remnants of the papal extortions. Interesting. Very, very interesting. But do not concern them in all ecclesiastical causes, appointed by the king's commission under his great seal in issuing out of chancery, to represent his royal person, the royal person being a corporation soul. and hear all appeals to him made by virtue of the before-mentioned statute of Henry VIII. His commission is usually filled with the lords spiritual and temporal, judges of the courts of Westminster, and doctors for the civil law. Oh, doctors are at civil law. Okay, it's starting to make sense now. Appeals to Rome were always looked upon by the English nation, even in the times of the popery, with an evil eye, as being contrary to the liberty of the subject, the honor of the crown, and the independence of the whole realm, and were first introduced in very turbulent times in the 16th year of King Stephen, in the year 1151. At the same period, Sir Henry Spelman observes that the civil and canon laws were first imported into England, but in a few years after, to obviate this growing practice, the constitutions made at Clarendon, 11 Henry II, on account of the disturbances raised by the Archbishop Becket and other zealots of the Holy See, expressly declare that appeals in causes ecclesiastical ought to lie from the archdeacon to the diocesan, from the diocesan to the archbishop of the province, and from the archbishop to the king, and are not to proceed any farther without special license from the crown. But the unhappy advantage that was given in the reigns of King John and his son Henry III to the encroaching power of the Pope, who was ever vigilant to improve all opportunities of extending his jurisdiction hither, at length riveted the custom of appealing to Rome in causes ecclesiastical so strongly that it never could be thoroughly broken off, till the grand rapture happened in the reign of Henry VIII, when all the jurisdiction usurped by the Pope in matters ecclesiastical was restored. So that's the grand rupture. Oh, grand rupture. Grand rupture. It was restored the crown to which it originally belonged, so that the statute 25 of Henry VIII was but declaratory of the ancient law of the realm. But in the case of the king himself be party in any of these suits, the appeal does not then lie to him in chancery, which would be absurd, but the statute 24 Henry VIII to all the bishops of the realm, assembled in the upper house of convocation. A commission of review is a commission sometimes granted in extraordinary cases to revise the sentence of the court of delegates, when it is apprehended they have been led into a material error. This commission the king may grant, although the statutes 24 and 25 of Henry VIII, before cited, declare the sentence of the delegates definitive, because the Pope, as supreme head by the canon law, used to grant such commission of review, and such authority as the Pope heretofore exerted is now annexed to the crown by statutes 26 Henry VIII and 1st Elizabeth, circa 1, but it is not a matter of right, which the subject may demand ex debito justitiae, as due to justice, but merely a matter of favor, and which therefore is often denied. These are now the principal courts of ecclesiastical jurisdiction, none of which are allowed to be courts of record, no more than was another much more formidable jurisdiction, but now deservedly annihilated, viz. the court of the King's High Commission in causes ecclesiastical. This court was erected and united to the regal power by the virtue of the statute, Statute 1 of Elizabeth, instead of a larger jurisdiction which had before been exercised under the Pope's authority. It was intended to vindicate the dignity and peace of the Church by reforming, ordering, and correcting the ecclesiastical state and persons, and all manner of errors, heresies, schisms, abuses, offenses, contempts, and enormities, under the shelter of which very general means were found in that and the two succeeding reigns to vest in the High Commissioners extraordinary and almost despotic powers of fining and imprisoning, which they exerted much beyond the degree of the offense itself, and frequently over the offenses, by no means of spiritual cognizance. For these reasons, this court was justly abolished by statute 16th of, I'm not sure who that monarch was, and the weak and illegal attempt that was made to revive it, during the reign of King James II, served only to hasten the infatuated prince's ruin. Next, as did the courts military, the only court of this kind known to and established by the permanent laws of the land in the courts of chivalry, formerly held before the Lord High Constable and Earl Marshal of England jointly. Start no wonder it makes sense why they have certain names. But since the attainder of the Stafford Duke of Buckingham under Henry VIII and the consequent extinguishment of the office of Lord High Constable, it was usually with respect to civil matters been held before the Earl Marshal only. This court by statute 13 of Richard II has cognizance of contracts and other matters touching deeds of arms and war, as well as out of the realm as within it, and from its sentences an appeal lies immediately to the king in person. This court was in great reputation in the times of pure chivalry, and afterwards during our connections with the continent by the territories which our princes left held in France, but is now grown almost entirely out of use on account of the feebleness of its jurisdiction and want of power to enforce its judgments, as it can neither fine nor imprison, not being a court of record. The maritime courts, or such as have power and jurisdiction to determine all maritime injuries arising upon the seas or in parts out of the reach of the common law, are only the Court of Admiralty and its courts of appeal. The Court of Admiralty is held before the Lord High Admiral of England, or his deputy, who is called the Judge of the Court. It sounds very reminiscent. According to Sir Henry Spelman and Lombard, it was first of all erected by King Edward III. Its proceedings are according to the method of the civil law, like those of the ecclesiastical courts, upon which account it is usually held at the same place with the superior ecclesiastical courts, any more than the spiritual courts. From the sentences of the Admiralty Judge, an appeal always lay, in ordinary course, to the King in Chancery, as may be collected from Statute 25 of Henry VIII, which directs the appeal from the Archbishop's courts to be determined by persons named in the King's Commission, like as in the case of appeal from the Admiral Court. But this is also expressly declared by Statute 8 of Elizabeth, which enacts that upon appeal made to the Chancery, the sentence definitive of the delegates appointed by commission shall be final. Appeals from the Vice Admiralty courts in America. What? It's sounding so similar now. I wonder why. And our other plantations and settlements. I hope everybody caught that part. May be brought before the courts of Admiralty in England, as being a branch of the Admiral's jurisdiction, though they may also be brought before the King in Council. But in case of prize vessels, taken in time of war, in any part of the world, and condemned in any courts of Admiralty or Vice Admiralty as lawful prize, what is prize in rem, of appeals consisting chiefly of the Privy Council and not to the judge's delegates. Good stuff. And this by virtue of the diverse treaties with foreign nations, by which particular courts are established in all the maritime countries of Europe for the decision of this question, whether lawful prize or not. For this being a question between subjects of different states, it belongs entirely to the law of nations, jus gentium, and not to the municipal laws of either country to determine it. I hope everybody caught that as well. I'm going to read that one again. Yes, they are. And this by virtue of the diverse treaties with foreign nations, by which particular courts are established in all the maritime countries of Europe. Remember, Europe being here in America, in the Old World. Before New York, while it was still considered Old York, England. whether law in all the maritime countries of Europe for the decision of the question, whether lawful prize or not, for this being a question between subjects of different states, it belongs entirely to the law of nations, and not to the municipal laws of either country to determine it. The original court, to which this question is permitted in England, is the Court of Admiralty. And the Court of Appeal is in effect the King's Privy Council, the members of which are, in the consequence of treaties, commissioned under the Great Seal of this purpose. In 1748, for the more speedy determination of appeals, the judges of the courts of Westminster Hall, though not privy councillors, were added to the commission then in being. But doubts being conceived concerning the validity of that commission, on account of such addition, the same was confirmed by Statute 22nd of George II, with a provision that no sentence given under it shall be valid unless a majority of the commissioners present were actually privy councillors. But this did not, I apprehend, extend to any future commissions, and such an addition became indeed wholly unnecessary in the course of the war, which commenced in 1756. Since during the whole of that war, the Commission of the Appeals was regularly attended and all its decisions conducted by a judge whose masterly acquaintance with the law of nations was known and revered by every state in Europe. That was super key. I didn't think it was going to go into that like that. Yep. So this was a very, very important one. I'm gonna save this. I'm gonna save it sometime. So, on that note, any questions so far? Yeah, I'll save it. I have it, just not with the Latin translations. Latin translations were key. They spoke more languages back in the day. That's why they quote Latin without translating it a lot of times. So, yeah, that was definitely super key. So this is why people like Boris say that you have to go by the laws of nations. If you don't understand international law, you're lost at sea. So let's see what else. So that was very, very telling. Of disturbance, of injuries, of personal issue of demurrer, of nuisance, of pleading, proceedings. Let's see what this is. A redress by operation of law. Short one. So, on the redress by the mere operation of law, the remedies for private wrongs, which are affected by the mere operation of law, will fall within a very narrow compass, there being only 2 instances of this sort that at present occur to my recollection. The one, that of retainer, where a creditor is made executor or administrator to his debtor. The other, in the case of what the law calls a remitter. Oh, this was amazing. I'm glad I clicked on this one. Alright. If a person indebted to another makes his creditor or debtee his executor, or if such creditor obtains letters of administration to his debtor, In these cases, the law gives him a remedy for his debt by allowing him to retain so much as will pay himself before any other creditors whose debts are of equal degree. This is a remedy by the mere act of law, and grounded upon this reason, that the executor cannot, without an apparent absurdity, commence a suit against himself as representative of the deceased, to recover that which is due to him in his own private capacity, but having the whole personal estate in his hands, so much as is sufficient to answer his own demand, is, by operation of law, applied to the particular purpose. Else, by being made executor, he would put in he would be put in a worse condition than all the rest of the world besides. Yes, they were all international. You have to remember. So just to provide context, though it's frowned upon by mainstream narratives, by supposed historians who are in essence charlatans and frauds, basically, they really can't say a lot because, it's in the city seals, it's in the city, the individual histories of the cities themselves. All of these different places in America, and especially here in North America, you have the old England, you have all these different older cities, you have France, encompassing parts of Texas, Louisiana, and other places with the Louisiana Purchase, and prior, because of those old treaties, you have other courts, other things going on, those different things. So there were a bunch of different things, going on, and they were all a bunch of different countries. So you have Babylon, which is there in New York. You have, Plains of Abraham there in Canada, parts of either the origins or the principal places of these ancient empires. So, between the different jurisdictions, why there's such wars, such as the treaty, that were concluded with the Treaty of Westphalia, the 30 Years War, the French Indian War, all these things. They were all international, but in essence, they were civil a lot of times because they were dealing with fights over land or sea. But yeah, it's always been under the law, international law. For though a ratable payment of all the debts of the deceased in equal degree is clearly the most equitable method, yet as every scheme for a proportionable distribution of the assets among all the creditors hath been hitherto hired to found to be impracticable, and productive of more mischiefs than it would remedy, so that the creditor whose first commences his suit is entitled to a preference in payment, it follows that as the executor can commence no suit, he must be paid the last of any, and of course must lose his debt, in case of the estate of his testator should prove insolvent, unless he be allowed to retain it. The doctrine of retainer is therefore the necessary consequence of that other doctrine of law, the priority of such creditor who first commences his action, but the executor shall not retain his own debt in prejudice to those of a higher degree, for the law only puts him in the same situation as if he had sued himself as executor and recovered his debt, which he never could be supposed to have done while debts of a higher nature subsisted. Neither shall one executor be allowed to retain his own debt in prejudice to that of his co-executor in an equal degree, but both shall be discharged in proportion. Nor shall an executor of his own wrong be in any case permitted to retain. Yeah, these are what's governing everything today. 2. In a remitter. Sounds like remittances. Is where he who hath the true property or jus proprietatis and lands, but is out of possession thereof, and hath no right to enter without recovering possession in an action, hath afterwards the freehold cast upon him by some subsequent and of course defective title. In this case he is remitted or sent back, which is what remit means. Miss or mit means to send. That's why you have the word transmitted. It means to send across. Trans means across. Or sent back by operation of law to his ancient and more certain title. This right of entry, which he hath gained by a bad title, shall be ipso facto annexed to his own inherent good one, and his defeasible estate shall be utterly defeated and annulled by the instantaneous act of law without his participation or consent, as if a deceases be, that is, turns him out of possession and dies, leaving a son C. Hereby the estate descends to the C. The son of A and B is barred from entering thereon till he proves his right in action. Now, if afterwards C, the heir of the deceaser, makes a lease for life to D, with remainder to B, the deceasee for life, and D dies, hereby the remainder accrues to B, the deceasee. Oh my word, that is complicated. But you have to understand what's happening. This is the case because, think about it, that you have certain national debts that were paid, and what they sought to do was they sought to appoint everyone executors of their estates. So they were seeing, if you're unaware of how the process goes, all the debts of the estate have to be paid before the executor can be paid, which is why it's such, if you don't know how probate, to properly probate certain things and handle certain things in court, you're seen as having a inferior title, or right, to the estate. Possession, and dies, leaving a son, C. So C is the son. Wait, but whose son is C? Is C's son A or B's son? If A deceases B, and then it turns out him out of possession, A's son is C. C is A's son. Hereby the estate descends to C. So the son of and B is barred from entering thereon till he proves his right in action. Now if afterwards C, the heir of the deceasor, makes a lease for life to D, with remainder to B, the deceasee for life, and D dies, hereby the remainder accrues to B, the deceasee, who thus gaining a new freehold by virtue of the remainder, which is a bad title, is by act of law remitted, or in of his former and surer estate, for he hath thereby gained a new right of possession, which the law immediately annexes his ancient right of propriety. Oh my word, that's wild. That sounds like exactly what's going on today. So, I gotta read that again. As if A deceases B. So if A takes possession of B's property, turns him out of possession, and dies, leaving his son C. So C, hereby the estate descends to C, the son of A. And B is barred from entering thereon. So if we consider most people are in the position of B today, thereon till he proves his right in action. Now if afterwards C, the heir of the deceasor, makes a lease for the life to D. So D is basically just a third-party intermeddler. Well, it depends on who has the actual right. Let's just presume, for an example, that B has the actual right to the property. And D is considered the third party with no real interest or equitable interest. With the remainder to B, the disseizee for life, and D dies. Hereby the remainder accrues to B, the disseizee, who thus gaining a new freehold by virtue of the remainder, which with the remainder is the beneficial interest after everything is paid out of the estate for any debts and credit, debts due by any creditors, which is a bad title, is by act of law remitted again, so it's sent back to him. So it makes a full circuit. So that's what it means by, that's what, okay. I know what they're talking about with remittance now. Oh, man. Oh, sheesh. These people. Oh, man. Oh, man. Getting a new title, law remitted to his former insurer estate, for he had gained by again, and the law annexes his ancient right of propriety. If the subsequent estate or right of possession be gained by a man's own act or consent, as by immediate purchase, being of full age, he shall not be remitted. For the taking such subsequent estate was his own folly, and shall be looked upon as a waiver of his prior right. Therefore, it is to be observed that every remitter, there are regularly these incidents, an ancient right and a new indefeasible estate of freehold, uniting in one and the same person, which defeasible estate must be cast upon the tenant, not gained by his own act or folly. The reason given by Littleton why this remedy, which operates silently and by the mere act of law, was allowed is somewhat similar to that given in the preceding article, because otherwise he who hath right would be deprived of all remedy. For as he himself is the person in possession of the freehold, there is no other person against whom he can bring an action to establish his prior right, and for this cause the law doth adjudge him in by the remitter, that is in such plight as if he had lawfully recovered the same land by suit. For as Lord Bacon observes, the benignity of the law is such as when to preserve the principles and grounds of law, it depriveth a man of his remedy without his own fault. It will rather put him in a better degree and condition than in a worse. Nam quod remedio destituiter ipsa re valet, si culpa absit. But there shall be no remitter to a right for which a party has no remedy by action, as if the issue in trial be barred by the fine or warranty of his ancestor, and the freehold is afterwards cast upon him, he shall not be remitted to his estate. Tail. For the operation of the remitter is exactly the same, and the union of two rights, as that of a real action would have been before it. As therefore the issue and could not by any action have recovered his ancient estate, he shall not recover it by remitter. And thus much of these extrajudicial remedies, as well for real as personal injuries, which are furnished by the law, where the parties are so peculiarly circumstanced as not to be able to apply for redress in the usual and ordinary methods to the courts of public justice. Oh, sheesh. This is why the court spiritual have to take effect. Oh my word, that makes so much sense. Yeah, that's how it's always been. And now I understand remitter. This is why certain people that benefit from the system right now cannot claim certain things. That makes so much sense now. So, yeah. Wow, that's wild. Yeah. The people in power right now, everything comes full circle. Wow.
So if people are benefiting right now before everything falls, the likelihood of them being able to claim a better estate by operation of law is different. Yeah.
Wow. That's wild.
That makes a lot of sense. Yeah. That was wild stuff. You definitely understand what remittances are. Understanding what disseizing and what season is, basically taking possession or livery of something. It's in the drive. It's William Blackstone's Commentaries on the Laws of England, and this is of redress by the mere operation of law. Blackstone's Commentaries on the Laws of England, Book 3rd, Chapter 2nd, of redress of mere operation of law. That's this one. I've been reading predominantly out of Blackstone's Commentaries on the Laws of England. Very insightful. I wish I had read it sooner. There's a lot to it. I've read some of them, not all of them. But, yeah. Very, very influential stuff. But it depends on how you get your estate. If you get it one way, you may not be able to recover it another. If you get it and you that's why these celebrities and other people can't do certain things. It makes so much sense. Wow. They can't do certain things because they got part of their estate, even though they don't control it. Yep. So, yeah. If you're ever curious about where this stuff originated from, they do, but the problem is they're not trying to give you a higher title than the state does. So, yeah, they do have something like that, but you have to be able to, you have to be able to see between the lines and stuff like that, because they're not going to tell you. They won't. And cost them their jobs? Nah, they don't want to do that. Supposed to be public servants, but they don't do a lot of serving. The most they might try to serve you is with a warrant. That's it. Sheesh. Beyond that, they're not really trying to help. But I'll see about probably reading one more. That one was good. That one was real good. Let's see. Yeah. Well, a reserve is essentially serving something again for a particular purpose. It's usually held with public confidence or public trust. So reserves are generally meant to serve the people or the beneficiaries that are dependent upon that trust or that reserve. That's what it means. So they act like a government agency, but they're not. So this was of redress by mere operation of law.
This was amazing. Glad I read that. Of redress, subtraction of the cognizance. Ooh, let's look at this one. I know what this one is. So it says, of waste. The fourth species of injury that may be offered to one's real property is by waste, or destruction in lands, tenements. Waste was considered at large in a former volume, as it was a means of forfeiture, and thereby transferring the property of real estates. In the cases of Sestake v. and estates pure outre v. That's what it's for. Because one of the main was the action of waste. So let me see. Probably I shall therefore here only beg lease to remind the student that waste is a spoil and destruction of the estate, either in houses, woods, or lands, by demolishing not the temporary profits only, but the very substance of the thing, thereby rendering it wild and desolate, which the common law expresses very significantly by the word vastum, and that this vastum, or waste, is either voluntary or permissive, the one by actual and designed demolition of the lands, woods, and houses, and the like. So that my only business is at present to show to whom this waste is an injury, and of course who is entitled to, nay, and what remedy be action. The persons who may be injured by waste are such as have some interest in the estate wasted. For if a man be absolute tenant in fee simple, without any encumbrance or charge on the premises, he may commit whatever waste his own indiscretion may prompt to. So this is only in the cases of trust. Because if you own your estate and you're the owner in fee simple, then yeah, you can't. What is there then? So it says no man is killed. Let me see. Without being impeachable or accountable for it to anyone. And though heir is sure to be the sufferer, yet nemo est heirs viventis. No man is certain of succeeding to him, yet nemo is nobody est. Nemo est heirs viventis. Sheesh. Well, fee simple is different than fee simple absolute. Fee simple absolute is a sovereign title. Fee simple is essentially the legal owner of the property. Let me see. So it says nemo est heirs viventis. No one is heir to the living. Okay. Okay. That makes sense. Okay. Nemo est heirs viventis. Nemo is nobody. So nobody is an heir to the living. Okay. Replevin, yeah. Oh, sheesh. See. Okay. No man is certain of succeeding him, as well on account of the uncertainty which shall die first, as also because he has it in his own power to constitute whate'er he pleases, according to the civil notion. So an heirs natus, an heir of birth, or an heir of nativity, and an heirs factus, an heir by deed or creation, or in the more accurate phraseology of our English law, he may alien or devise his estate to whomever he thinks proper, the right of disposition of property, and by such alienation or device may disinherit his all law, into whose hands forever therefore the estate wasted comes after a tenant in fee simple. Though the waste is undoubtedly damnum, it is absque injuria. I'm pretty sure that means whose injury they don't know. One species of interest which is injured by waste is that a person who has a right of common in the place wasted, especially if it be common of estovers, or a right of cutting and carrying away wood for houseboat, plowboat, etc. Here, if the owner of the wood demolishes the whole wood and thereby destroys all possibility of taking estoves, this is an injury to the commoner, amounting to no less a disseason of his common of estovers, if he chooses to consider it, for which he has his remedy to recover possession and damages by assize, if entitled to a freehold in such common, but he has only a chattel interest, that he can only recover damages by action on the case for his waste and destruction of the woods, out of which his estovers were to issue. Trover. Oh. But the most usual and important interest that is hused by his commission of waste is that of him who hath the remainder of or reversion of the inheritance after a particular estate for life or years in being. Here, if the particular tenant, be it the tenant in dower or by courtesy, who were answerable for waste of the common law, or the lessee for life or years, who was the first made liable by the statutes of Marlbridge and of Gloucester, in the particular tenant, if the particular tenant, I say, commits or suffers nay waste, it is a manifest injury to him that has the inheritance, as it tends to mangle and dismember it and its most desirable incidents and ornaments, among which timber and houses may justly be reckoned by principle. To him, therefore, in remainder or reversion, the law hath given a remedy, that is, to him to whom the inheritance appertains in expectancy. For he who hath remainder for life only is not entitled to the sue for waste, since his interest may never perhaps come into possession, and then hath suffered no injury. Yet a person, vicar, archdeacon, prebendary, and the like, who were seized in the right of their churches and of any remainder or reversion, may have an action of waste, for they, in many cases, have the benefit of her church and a successor of fee simple qualified, and yet as they were not as they were not seized, in their own right, the writ of waste shall not say an ex hereditan oi shall not say ad ex hereditationem ipsius as for the other tenants in fee simple, but ad ex hereditationem ecclesiastica, and whose right the fee simple is holden. The redress for this injury of waste is two kinds, preventative and corrective. The former of which is by writ of estrepement, the latter by that of waste. Estrepement is an old French word signifying the same as waste or extirpation, and the writ of extirpament lay at common law after judgment obtained in any action real and before possession was delivered by the to sheriff, stop any waste which the vanquished party may be tempted to commit in lands which were determined to be no longer his, but as in some cases the defendant may be justly apprehensive that the tenant may make waste and entrapment pending the suit, well knowing the weakness of his title. Therefore the statute of Gloucester gave another writ of entrapment pendente placito, commanding the sheriff firmly to inhibit the tenant ne faciat vastum vel indiscuso. Okay, so ne faciat, no waste, entrapment pending the place of indictment, it sounds like. So it sounds like an injunctive relief, and by virtue of either of these writs, the sheriff may resist them that do or offer to do waste, and if otherwise he cannot prevent them, he may lawfully imprison the wasters, or make a warrant to others to imprison them, or if necessity require, he may take the posse comitatus to his assistance. So odious is the fight of the law is waste and destruction. In suing out these two writs, this difference was formerly observed, that in actions merely possessory, where no damages were covered, a writ of estrepement might be had at any time pendente lite, pending litigation, nay, even at the time of suing out of the original writ or first process. But in an action where damages were recovered, the defendant could only have a writ of estrepement if he was apprehensive of waste after verdict had, for with regard to waste done after the verdict was given, it was presumed the jury would consider that in the assessing the quantum of damages. But now it seems to be held by an equitable construction of the statute of Gloucester, and in advancement of the remedy, that a writ of estrepement to prevent waste may be had in every stage, as well as such actions where damages were recovered. So those wherein only possession is had of the lands, for peradventure, faith of the law, the tenant may not be of ability to satisfy the demandant his full damages. And therefore now in an action of waste itself to recover the place wasted and also damages in a writ of estrepement will lie, as well before as after judgment. For the plaintiff cannot recover damages for more waste than is contained in his original complaint, neither is he at liberty to assign or give in evidence any waste made after the suing out of the writ. It is therefore reasonable that he should have this writ of preventative justice, since he is in his present suit debarred of any further remedial. If a writ of estrepement forbidding waste, directed and delivered to the tenant, as it may be, and he afterwards proceeds to commit waste, an action may be carried on upon the foundation of this writ, wherein the only plea of the tenant can be non fecit vastum contra prohibitionem, and if upon verdict it be found that he did, the plaintiff may recover costs and damages, or the party may proceed to punish the defendant for the contempt. For if, after the writ directed and delivered to the tenant or his servants, they proceed to commit waste, the court will imprison them for his contempt of the writ. But not so, if it be directed to the sheriff, for then it is incumbent upon him to prevent the estrepement absolutely, even by raising the posse comitatus, if it can be no other way. Besides this preventative redress at common law, the courts of equity, upon bill exhibited therein, complaining of waste and destruction, will grant an injunction or order to stay waste, until the defendant shall have put in his answer, and the court shall thereupon make a further order, which is now become the most usual way of preventing waste. Injunctive release. Good to know. A writ of waste is also an action partly founded upon the common law and partly upon the statute of Gloucester, and may be brought by him who hath the immediate estate of inheritance in reversion or remainder, says the KV, against the tenant for life, tenant in dower, tenant by the courtesy, or tenant for years. So you have to remember too, with Sesta KV estates, we are considered the remainder man, because we want to remain among the living, and they are considered the tenant of our names. They don't have the right of remainder. All they have the right is of season or current possession. So, that's not their former estate. They are the tenant for life. So they are the tenant on our names. One tenant in common for the inheritance of the other, against the tenant for life, tenant in dower, tenant by the courtesy, or tenant for years. This action is also maintainable in pursuance of the statute Westminster by one tenant in common of the inheritance against another who makes waste in the estate holden in common, the equity of which statute extends by joint tenant, but not to co-parceners. Because of the old law, co-parceners might make partition, whether either of them thought proper, and thereby prevent future waste, but tenants in common and joint tenants could not. And therefore the statute gave them this remedy. Compelling the defendant either to make partition and take the place wasted to his own share, or give security not to commit any further waste. But these tenants in common and joint tenants not liable to the penalties of the statute of Gloucester, which extends only to such as have life estates and do waste to the prejudice of the inheritance. The waste, however, must be something considerable, for if it is amount only to 12 pence, or such petty sum, the plaintiff shall not recover in an action of waste, nam de minimis non curat lex. I'm going to look that up. The law does not concern itself with trifles. Expression of their rule is that the law will not remedy an injury that is minimal. This action of waste is mixed, partly real so far as it recovers land, and partly personal so far as it recovers damages. For it is brought for both those purposes. What's going on? And if waste be proved, the plaintiff shall recover the thing or place waste, and also treble damages by the statute of Gloucester. The writ of waste calls upon the tenant to appear and show cause why he hath committed waste and destruction in the place named, ad ex hereditationem, in disinheritance of the plaintiff. And if the defendant makes default or does not appear at the day assigned him, Then the sheriff is to take with him a jury of 12 men, go in person to the place alleged to be wasted, and there inquire to the waste done and the damages, and make a return or report of the same to the court, upon which report the judgment is founded. For the law will not suffer for so heavy a judgment as the forfeiture and treble damages to be passed upon a mere default, without full assurance that the fact is according as it is stated in the writ. But if the defendant appears to the writ, and afterwards suffers judgment to go against him by default, or nihil dicit, judgment where nothing is said, when he makes no answer, puts in no plea in defense, this amounts to a confession of the waste. He is plea by acquiescence, since having once appeared, he cannot pretend ignorance of the charge. Now therefore the sheriff shall not go in the place to inquire the fact, whether any waste has or has been obtained by the silent confession of the defendant, but he shall only, as in defaults upon other actions, make inquiry of the quantum of damages. The defendant on the trial may give evidence anything that proves there was no waste committed, as that the destruction happened by lightning, tempests, the king's enemies, or in other inevitable accident. But it is no defense to say that a stranger did the waste, for against him the plaintiff has no remedy, though the defendant is entitled to sue such stranger in an action of trespass via et armis, and shall recover the damages he has suffered in consequence of such unlawful act. When the waste and damages are thus ascertained, either by confession, verdict, or inquiry of the sheriff, judgment is given, in pursuance of the statute of Gloucester, that the plaintiff shall recover the place wasted, for which he has immediately a writ of possession, provided the particular estate be still subsisting, for if it be expired, there can be no forfeiture of the land, and also that the plaintiff shall recover treble damages assessed by the jury, which he must obtain in the same manner as all other damages in actions personal and mixed are obtained, whether the particular estate is expired or still in being. So, a lot there, but it says in there in the Cestui V Acts that there is an action of waste that can be held against the lords, but it's difficult to prove. So, something to consider though. But probably go another 15, 20 minutes. Any other questions on what we covered? I know we covered quite a bit. There was a lot as far as that. Hope everyone was paying attention about the international law. Any questions on that? Any other questions? Maybe other than what was covered today as well? A discharge in law generally is when you're no longer liable for a debt. So, a discharge is contrasted with settlement, closure, and termination of debts. A discharge is also seen as, essentially the debt still exists, but you're no longer liable for it. That's generally what a discharge in law is. So I hope that answers. I hope that kind of answers it for you. It's also kind of it's different than assigning debts, because if you assign a debt or endorse something and deliver a debt to another party, then it becomes their debt. Also depends, as long as they accept it, but I think what you're more talking is like, I don't know. There's two different occasions when I can think of when reserves are released. When reserves are released, there's either one, it's being held as surety for some reason, either surety for performance or surety for a debt, which is still performance. Actually, realistically, either way, because it's a duty owed. A duty can mean particular property conveyed, or it can mean certain performance under a contract or agreement. So one way is through exoneration. If collateral is held as surety or security for the repayment of a debt until certain payments have been made, and then the collateral they're exonerated. That is one occasion when the reserves or proper technically are released. Another occasion is when in the true definition of reserve, the reserve is a trust, which is why you have Indian reserves. This is why you have reserves of funds. This is why you have maybe federal reserves. So the reserves being released is thereby either dispersed or put back into the public or to the beneficial owner. So it can be also in the case of disbursement and the winding up of a trust. If there's a winding up of a trust, then reserves are dispersed, and possession and livery is then taken by the beneficiary or the cestake use of the property of the estate, and then the beneficiary becomes the owner in fee simple. So those are two occasions when I can think of when reserves are technically released, are technically released, is under exoneration and in winding up of trusts. So, yeah. Absolutely, Mike. But yeah, contrasted it with discharge. Discharge is just the debt itself is just held, or performance of the debt is actually generally assigned to another, and you're no longer liable for the performance of the debt or the repayment of the debt, even though the debt still technically exists. So it's different in those two senses as well, just so you know. Or those, or exoneration and winding up of trusts versus discharge. Exoneration can be like one case of exoneration is essentially when someone's name is cleared of all charges and they're exonerated from certain charges under their name, basically indictments for otherwise. So that's an example of exoneration. But under suretyship, exoneration would be essentially no longer liable for a debt, or to have to make sure or be security for another. Land Transfer Act. No, I haven't. Land Transfer Act. Let's see. So this is all dealing with at-law possession of vessels. Okay. Persons not affected upon proper construction of Georgia land registration law. Its provisions do not apply to a person who is not made a party to proceedings instituted thereunder. Okay.
Deeds conveying title to all registered estates shall be recorded in the same manner as deeds conveying title to unregistered lands are recorded. All previous conveyances of interest in registered lands by the last registered owner or said owner's representatives, heirs, or sons, and recorded in the deed records in the office of the clerk of the Superior Court in which this land is situated shall be valid transfers of said interests. Upon request, the clerk of the Superior Court is authorized to note the title register information regarding the transfers. Just talking about real property. The other issue is that a lot of times it's not really always considered real property. The estate kind of moves as immovable chattels or immovable or signified by intellectual property. So it's not always by real property, but it's a good thing to note. Another 5-10 minutes. Any other questions? Any other questions? Any other questions for the night? Let me know. Are these transfers to registered proprietors? Not totally sure. It depends on what type of title to property you're talking about. Whether you're talking about real property, chattels, intellectual property, accounts, receivables, accounts payables, etc. That just depends on what you're talking about. Land, I'm not sure. I'm not really sure. Land is, if you're talking specifically about real property, I'm not totally sure. But, generally speaking, if you're considered if you're referring to the land owners as, the fee simple owners, yeah, I don't know. I'm not terribly certain. I haven't looked at that act in too detail, as far as land registration. I just know that how property is conveyed according to essentially the languaging in older laws. Oh, okay, you're talking about yeah. Okay, so that's the owner fee simple then. Yeah. If you're referring to the minor accounts and stuff like that, in this aspect, I don't think that's how they transfer the accounts. They transfer the accounts as chattels, chattel paper, accounts receivables, intangibles, things like that. They don't necessarily treat it in the same manner because of certain acts that I can't go over right now. But there are certain acts that essentially allow
real property to be, certain types of real property to be seen as essentially chattels or, fixtures or appurtenances to, estates or intangible properties. So, yeah, there are times when land is conveyed differently. Just depends on what it is. Yeah. Well, succession, yeah, absolutely. That's considered like the descent of a chosen action or a right of action. But a transfer is generally considered like a direct chain of title instead of passing through testacy and things like that. I know what you're talking about. But like I said, it depends, because a lot of those things are not necessarily, they're not handled like that. So, because there are such things as portable lands in law and in equity. So, it just depends on what the case may be. If you're talking about property and houses, like actual houses and land, then, transfers have to be according to certain things because of certain, martial law and occupations of land and stuff, certain things like that. What's going on, David? You late to the show? So, any other questions? Yeah, well, I mean, tenants in common is referring to tenants of the life estate, meaning that they construe you to only be the current possessor of the property and having right of possession, but not the right of beneficial ownership. So tenants in common, or joint tenants in common, often referred to tenants of the life estate, not the remainder man or the right of the use of the property, which is why a lot of people owe taxes, I wonder. Yeah, there's not really native per se courts unless you are a native to certain Indian reserves. Or are you talking to Miss One over there? Any other questions? Probably go another like 10-15 minutes. Land tax on investment property and give native title land. Have not yet. Well, investment properties are seen as commercial in nature because you're driving up rents or profits. That's under the SKV Act. Because commercial properties are not good by nature. Because rents and profits are unlawful. Like rents are unlawful, excuse me. I'm not sure how much I can talk about that, David, right now. I really do want to, but I'm not sure how far I can go in that. All I gotta say is look at your deed and what the consideration is. If it says $10, it might be for another reason than you think. Regardless of what the promissory note says, regardless of whether the tenant, the tenant on the property could be a clue, and the $10 could be a clue, but I can't really talk about that right now. Most lands are still considered crown lands. That goes for most UK jurisdictions. Well, it depends on how the house is and the land is conveyed. If the wording on the deed conveys it differently, there may actually be an opportunity, especially in Australia. But, it just depends. You'd have to sue for certain things to be recovered. But if that's the case, then you might want to put it under your business anyway. That way the business is considered the tenant instead of you, and you own the business. Huh. Yeah, I mean, it's similar to the current plat system that's over here, but it just depends on the language in the deed, or the conveyance that's moving or transferring the property from one owner to another. That's really what matters. There's a difference between a legal description and a lawful description. Legal meaning all caps, lawful meaning upper and lower. Generally speaking, yeah, I think you're on the right track, David. Yeah, that's something specific to North America, particularly. Common law traditions talk about 21 silver dollars as part of consideration. So, any jurisdiction that generally has common law traditions might be something to pursue, but generally it's in the language dealing with the consideration. Well, if you're seen as the sole fee simple owner on the property and you're not properly acknowledged in law and it's not held under a business, then technically the registry owns it. I haven't come across a land patent process that's actually like legitimate. The BLM, it's not land patents through the BLM is not really worth it, or particularly like effective. And then you consider like other so-called land patents, but it's only as good as the one that previously held the title before them. So I don't really see the point in it. The best thing I would say is being fee simple owner of the property and conveying it to a foreign, a properly established irrevocable trust. Taxes would have to be paid on the deed. In that essence, certain types of duties. But that's as close as you can really get to it, right now. And then making sure it doesn't have any easements or mineral rights, any processes or clauses for escheatment in the deed itself. But yeah, making sure that you have the ability to convey that ownership of property into there without being subject to easements or things like that. But yeah, technically you're supposed to have 21 silver coins. I've heard that if you bury well on the land, you can get that. You can, but you got to change the status of your property to show it's a cemetery. You actually have to do the paperwork to change your status of your property. But I'm pretty sure that you can. I'm not familiar with all the ins and outs of that, but I've heard of it before. And it's definitely something you'd have to pursue further. I've definitely heard it though. I don't know what that's in reference to, Ms. One. I don't know. I really don't know what that's talking about. If you're talking about the land still, there's one thing. You might be right on that, David. Can't really elaborate on that, but you might be onto something. Oh. Yeah, I mean that makes sense. You have to, so they hold the ownership, some type of interest in the lands, and to pass them, it changes. This is why people put houses in trusts, and then they sell the trust to another instead of changing the title on the deed. Sheesh. That's generally what they want to do. They want to make sure that it wasn't a foreign investor. But alright. Probably go another 5-10 minutes. Oh, yeah, that's different. That's taxes have to be paid on conveyances and transfers, yeah. You gotta get well, like I said, businesses are private citizens, so proprietary limited company owned by a trust. And that proprietary limited company is the citizen. And in the case of mortgages, it just depends. Mortgages are generally considered escrow or trust accounts, so it's going to have a priority interest over any debtor-creditor rules. Absolutely, David. Yeah. Well, it's been wonderful. Grateful y'all took the time out of your day to stay on and listen in. If you need to set up a trust, the BOI filings to FinCEN have been paused pending that litigation in federal court. So, there's no current need for that. I will say it's still good to have your business in a trust because there are capital gains if you are the personal owner. Absolutely. So, like I said, if you need a trust set up, let me know. Just fill out the form on my website. We'll figure out a time that works. If you'd like to set up a consultation with me one-on-one, you can do so. Like I said, also just please fill out my contact info on my website and then continue there. And let me see. So beyond that, let's see. Other than that, if you'd like to, find out more about what's going on, including other remedies at law and predominantly in equity, as equity follows the law. We do have the private equity weekly workshop on Mondays and Fridays. Monday's the study session, and Fridays is the the workshop. So it's all held on Zoom for members of the workshop. It's, if you'd like to join, it's a $200 donation for a lifetime membership. So just go ahead and let me know, and then send me a message. And yeah, and then that's where we go over the stuff I can't talk about. At least not in the public. There's some things that I really, quite frankly, wish I could, but there's certain things that prevent me from doing so. So yeah. Other than that, like I said, like, share, subscribe, share with other people that you know. But thank y'all for joining. Y'all have a wonderful night. And this is B with To Be Fruitful Training Group. I'll see y'all on the next one. Good night, y'all.